Chapter 1329. Point of sale inspection 1329.01 certificate of inspection required. 1329.02 application and issuance. 1329.03 compliance documents. 1329.04 fees. 1329.05 required use of certificate of inspection. 1329.05 Class A violations. 1329.06 escrow agent obligations. 1329.07 reliance on certificate of inspection and compliance document. 1329.99 penalty. Cross-references Housing Code C Building. CH 1341 to 1353 Business Maintenance Code C Building. CH 1361 to 1371. 1329.01 Certificate of Inspection required. A. The owner of any dwelling structure, commercial building structure, or other building, or land upon which such buildings are located, entering into an agreement to sell or otherwise convey an interest in such land or building structures, shall obtain from the Commissioner of Buildings a certificate of inspection, and present such certificate, or an exact copy thereof, to any prospective purchaser or grantee prior to the time of transfer of title to the purchaser, in order to permit the escrow agent to comply with this chapter. The certificate of inspection shall list thereon all known violations of city codes determined from the inspection, as well as other informational material. ORD 46 to 1999. Passed April 5, 99. B. In the event any property as described in subsection A hereof is sold at sheriff's sale or other court-ordered auction for sale, or any person obtains title to the property for consideration by any means, and no certificate of inspection has been issued for said property within 1 year prior to the date of such sale or transfer of title, the purchaser or transferee of said property shall apply to the Commissioner of Buildings for a certificate of inspection within 30 days after the time of transfer of title to the purchaser or transferee. The failure of the purchaser or transferee to obtain and or file a deed with the county recorder shall not excuse the purchaser or transferee from compliance with this chapter. The purchaser or transferee shall further comply with all of the obligations of a seller under this chapter, including, without limitation, the duty to place funds in escrow for corrections of Class A violations. ORD 84 to 2007. Passed August 6, 07. 1329.02 application and issuance. Issuance. A. Application for a certificate of inspection required by the provisions of this chapter shall be made by the owner, or an agent for the owner, upon forms provided by the Commissioner of Buildings. The Commissioner shall inform the applicant that he/she has a constitutional right to refuse entry by city inspectors without a search warrant. If the applicant shall consent to the inspection, the parties shall then agree to a time during the working hours of the Division of Buildings, or at some other mutually agreeable time when the inspection is to be made. If the applicant refuses to consent to the inspection, the Commissioner shall procure a search warrant as provided by law to gain entry. B. The following schedule for issuing a certificate of inspection shall be followed, except where a longer period is required because of the larger number of units in a building or other causes beyond the control of the city. ORD 25 to 1984. Passed March 1984. March 19, 84. 1. Within 10 working days after receipt of the application and required fee, the Commissioner shall cause an inspection of the designated property to be made. ORD 42 to 1987. Passed May 4, 87. 2. The Commissioner shall then issue a certificate of inspection within 5 working days after gaining access to the subject property containing the following information: the street address, permanent parcel number, or other identifying characteristics of the property. B. The name and address of the owner, as defined in this chapter. C. The authorized use and occupancy of the structures or building. D. The listing of violations of the codified ordinances of the city existing. at the time of such inspection, and B. The current listing of water and sewer charges due against the property, the date of the last billing, and a statement contained therein that the purchaser of such property shall be responsible for any unpaid water and sewer charges existing as of the date of transfer. ORD 25 to 1984. Passed March 1984. C. Except in the case of danger to the public health or safety, the certificate of inspection shall contain the order of the Commissioner for the correction of any code violations noted on the certificate, which shall be corrected by the owner of the property within 90 days of the issuance of the certificate unless, for good cause shown, the Commissioner has extended the time for compliance. If the owner of a property does not comply with the violations enumerated in the certificate of inspection prior to the time the title is transferred to the purchaser, then the purchaser of that property shall be required to comply with the violations contained in the certificate of inspection within the time allotted in the notice given to the prior owner, as that time may be extended by the Commissioner. D. Such certificate of inspection shall be valid for a period of 1 year from the date of issuance. E. In case of resale within the 1 year period, this certificate shall be transferred to any subsequent bona fide purchaser and shall be valid for the remainder of that period. ORD 128-1980. Passed April 6, 81. 1329.03 Compliance Documents. A. At the request of the owner of property or his agent, the city shall issue a letter or other written document signed and dated by the Commissioner of Buildings stating that violations listed on a specific certificate of inspection have been completed to the city's satisfaction, when, in fact, all such violations have been corrected. B. At the request of the owner of property or his agent, the city may issue a letter or other written document signed and dated by the Commissioner stating that some, but not all, of the violations listed on a specific certificate of inspection have been completed to the city's satisfaction. ORD 51 to 1981. Passed May 4, 81. 1329.04 Fees. A. The fee charged for the certificate of inspection shall be $200 for the first dwelling or business unit in any building or structure, and an additional $50 for each additional dwelling or business unit in such building or structure. The fees shall be paid at the time the application for a certificate of inspection is filed with the city. ORD 201-2013. Passed December 16, 13. B. There shall be no fee for any reinspection requested by the same owner within 1 year from the date of issuance of a certificate of inspection for the same property. ORD 128-1980. Passed April 6, 81. 1329.05 Required use of certificate of inspection. I. No person, agent, firm, or corporation shall, in a bona fide sale for a good and valid consideration, transfer or convey any interest in a dwelling structure, commercial building structure, or other building or land upon which such buildings are located, without first providing the purchaser or prospective purchaser with a current certificate of inspection or an exact copy thereof as provided in this chapter. B. The seller shall deposit in escrow a statement signed by the purchaser acknowledging receipt of the certificate of inspection, and such signed statement shall list thereon the date the certificate was given to the purchaser. C. If, under the terms of the contract of sale, the seller is obligated to correct all violations listed on the certificate of inspection, the seller shall deposit in escrow before transfer of title to the purchaser either a compliance document described in section 1329.03 and or a written statement agreed upon by the seller and the purchaser filed with the escrow agent setting forth an agreed sum of money that is sufficient to cover the costs of correcting those specific violations listed on the certificate of inspection which remain uncorrected. D. If, under the terms of the contract of sale, the purchaser's obligation for correction of violations listed on the certificate of inspection is limited to contribution of a specifically stated dollar amount, or is limited to purchaser's obligation to correct specific, but not all, code violations, then the seller shall deposit in escrow either a compliance document described in section 1329.03, A. If, in fact, all such violations have been corrected, or a compliance document described In section 1329.03b, together with a written statement agreed upon by seller and purchaser filed with the escrow agent setting forth an agreed sum of money that is sufficient to cover the costs of correcting the violations listed on the certificate of inspection which remain uncorrected and for which the seller is responsible. B. If, under the terms of the contract of sale, the seller has either not agreed to correct all violations as provided in subsection C hereof, or the purchaser's obligation is not limited to payment of a stated sum of money, or to correction of specific violations as provided in subsection D hereof, then the contract of sale between the seller and the purchaser shall be conditional upon the seller and purchaser agreeing in writing after the certificate of inspection has been exhibited to the purchaser, as to their respective obligations for correction of the remaining uncorrected violations listed on such certificate. The seller and purchaser shall thereafter deposit in escrow, before transfer of title to purchaser, their written agreement as to each party's respective responsibility for correction of violations listed on the certificate of inspection remaining uncorrected, and such agreement may have attached thereto a compliance document described in section 1329.03b, evidencing seller's correction of those violations for which he is responsible, and or an agreed sum of money that is sufficient to cover the cost of correcting those violations remaining uncorrected for which the seller is responsible. F. This chapter sets forth requirements and procedures applicable to relationships between the seller and purchaser at the time of sale of real estate, as to code violations. Nothing contained in this chapter shall be construed as limiting the city, at any time, from proceeding against the owner of property to require correction of code violations, as the owner of property is defined in the codified ordinances. G. This chapter shall not apply to the individual transfer of property through inheritance or gift where no bona fide sale is intended or completed. ORD 51 to 1981. Passed May 4th, 81. 1329.051 Class A violations. A. The following types of violations are of particular concern to the city's vital interest in maintaining property values: exterior roof chimney paint, all related carpentry repairs, house and or garage, major porch and step repair, downspouts to storm sewers, replacement of deteriorated windows and or doors, concrete replacement or major repair, garage replacement or major repair, dead tree removal, fences, interior major electrical repair, panel replacement, rewire of basement, etc. Major plumbing repair, replacement of stacks, fixtures, supply lines, etc. HVAC foundation support post, block wall bowed or collapsed, major breach of ceilings, walls or floors. The aforementioned types of violations are considered to be Class A violations and shall be designated as such by the building commissioner on all inspection reports. B. Title to any property in the city shall not be transferred unless an escrow account with an amount of money equal to at least 125% of the estimated cost of correction of all outstanding Class A violations has been established and approved in writing by the building commissioner. In lieu of establishment of an escrow account hereunder, a purchaser may present proof of a commitment for a 203K or other rehabilitation loan from a recognized lending institution in an amount adequate to correct all Class A violations as approved by the building commissioner. C. No money shall be released from the aforesaid escrow account without the written approval of the building commissioner. D. Subsections C, E, and E of section 1329.05 shall not be applicable to Class A violations, which shall instead be governed by the provisions of this section 1329.051. E. This section shall apply to all applications for certificate of inspection submitted on or after November 5th, 2001. ORD 146-2001. Passed October 15th, 01. F. The requirement for depositing funds in an escrow account may be varied in whole or in part in particular instances by the city manager. The applicant for the variances is able to demonstrate to the city manager that 1. Special circumstances exist necessitating the variance from the requirements in order to make the sale and repair of the property financially practicable, and 2. The purchaser has the financial capability to correct the violations listed on the city certificate of inspection within a reasonable period of time, and 3. 3. The variance is in the best interest of the city and its residents. ORD 116-2010. Passed September 7, 10. 1329.06 Escrow Agent Obligations. No person, firm, or corporation acting in the capacity of an escrow agent in any real estate transaction involving the bona fide sale or conveyance of any interest in a dwelling structure, commercial building structure, or other building or land upon which such buildings are located in the city, shall file for recorded instrument to transfer title thereto or disburse any funds from such sale, unless the provisions of this chapter have been satisfied, including, but not limited to the specific provisions of section 1329.05, ORD 128-1980, passed April 6, 81. 1329.07 Reliance on Certificate of Inspection and Compliance Document. In issuing a certificate of inspection, the city does not thereby ensure, warrant, or guarantee to the holder thereof, to his assignees or any other interested party, that such certificate contains all of the violations of the codified ordinances of the city or statutes of the state. Such certificate should be considered by all parties as the city's best effort to make known to owners and purchasers of real estate the known violations on a given property at the time the inspection is made. A copy of this section, or a digest thereof, shall be contained in each certificate of inspection. B. In issuing a compliance document under the provisions of this chapter, the city does not thereby ensure, warrant, or guarantee the quality of repair or standard of work completed in the correction of violations listed on a certificate of inspection. Such document should be construed only as a statement by the city that some or all of the violations listed on the certificate of inspection have been corrected to the city's satisfaction. A copy of this section, or a digest thereof, shall be contained in each compliance document. ORD 51-1981. Passed May 4, 81. 1329.99 Penalty. Whoever violates any provision of this chapter shall be subject to the penalty provided in section 1311.99. ORD 42-1987. Passed May 4, 87. 1311.99 Penalty. Whoever violates any provision of this Part 13 Building Code, or the adopted Regional Dwelling House Code, or Ohio Building Code, or any rule or regulation promulgated thereunder, or fails to comply therewith, or with any written notice or written order issued thereunder, or whoever refuses to permit entry by the building commissioner or other city department heads or their representatives at a reasonable hour, or whoever interferes with, obstructs, or hinders the building commissioner or his authorized representatives while attempting to make inspections, or not otherwise specifically provided for, shall be fined not more than $1,000, or imprisoned not more than 6 months, or both. Each day such violation occurs or continues shall constitute a separate offense. ORD 156-2004. Passed October 18, 04.